Hello, my name is Regine Francois Williams. I am the managing attorney at Francois Williams Legal. We are a multi-regional law firm serving clients in Maryland, the District of Columbia, and South Florida. Today I come to you to speak to you about top considerations for a good power of attorney when talking in terms of an estate plan. So first, let me give you the definition of a power of attorney. A power of attorney is a document that provides for someone else as an agent to assist you in case you are still alive but incapacitated and cannot act for whatever reason, okay? And so here are the top considerations in my opinion. A good power of attorney should be effective immediately. While there are certain powers of attorneys that are springing in nature, and what I mean by that is there are conditions that must occur before your agent can act. So for example, I've seen powers of attorneys that set documents that say that, it only becomes into effect when the principal, i.e. the person giving away or delegating their power, is not able to act, and two physicians have determined that that person is in need of help, and or the court has adjudicated that person incapable of handling their finances. The reason that I don't particularly like that is because that creates a delay, especially when you may need the assistance to occur immediately. So I think that a power of attorney should be effective immediately unless you don't have a trusted individual. And what I mean by that is, in some cases, folks may not have really close family members. You may have to put your neighbor as your agent for your power of attorney. And so maybe you want to have some level of oversight and accountability, kind of like a checks and balances. But if you're identifying a trusted person for your power of attorney, which is what you should do generally speaking whenever possible, then I think it should be effective immediately. The second consideration is that your power of attorney should be durable. There are differences in terms of powers of attorneys. There can be a general power of attorney and a durable power of attorney. A general power of attorney generally ends upon incapacity. So you have this document and somebody can act for you until you are not able to act for yourself. And I think it really defeats the purpose when we're talking about estate planning to have general powers of attorneys. They're great for if you need somebody to help you with signing a prop on, executing a deed or whatever. But in terms of estate planning, when we're preparing for the unexpected, I think it should be durable. And the word durable in this case means that it lasts beyond incapacity. So it lasts when you actually need it, right? When you are incapacitated, when you are in a coma or whatever the condition is that you're not able to take care of yourself. But your power of attorney should be durable as it relates to the estate planning. The other consideration is that you should have multiple agents and alternates, right? So for example, if I have a power of attorney, I will identify a first person and say if they're not available or unwilling to serve, then I have a second person, and then if they're unavailable and unwilling to serve, then I have a third person. It's really important that you have at least 2 to 3 people, right? And the reason is things happen, right? What if I have a power of attorney that has person A and that person is unavailable, but I have no one else? So what happens to that document? Well, while your document is still valid, there's no one else to act for you, and it still would require the intervention of the court. So having 2 people, 3 people, like a first person, a second, first alternate, a second alternate, permits for those types of contingencies. It can, in case people are unavailable and or they're unwilling to serve, because that can happen as well. Fourth consideration, a good power of attorney should have some level of Medicaid planning or give your agent the ability to do Medicaid planning. Oftentimes, when powers of attorneys are done for people that are younger in age, right? They don't include that language. And then you have this document for 15, 20, 30 years. And then you are in need of Medicaid planning. You need nursing home care. You need help with your activities of daily living. And your document does not provide for that. So what happens in that case? Either we have to get a restricted or some sort of limited order from the court, or we have to do a full guardianship, right? In order to be able to do Medicaid planning for the person. So it really defeats the purpose of having one if you don't have such a critical provision in your power of attorney. And the last one, you should have one. It is my opinion that everybody over the age of 18 should really have a power of attorney. You never know when you may, for whatever reason, health or otherwise, cannot act for yourself. And so you really should have somebody, hopefully, that is a trusted individual that you feel you can delegate those financial planning or financial tasks to. So, I think having one is really critical. That's where the barrier starts, right? In order to make sure that in case of incapacity, in case of you're unable to act for yourself for whatever reason, health or otherwise, that there is somebody eligible and capable to assist you with those decisions so that your finances don't fall, your rent is not unpaid, your mortgage is not unpaid, and so forth. So I hope you've enjoyed this presentation on top considerations for a good power of attorney. And hopefully, if you don't have one, that you will consider having a trusted attorney draft one. They should be documents that are individually drafted to your specification, to your lifestyle, to your goals, right? These are not, documents that are just spit out of the computer. So really, they should be made to be individualized documents to fit your life. And so thank you for watching, and I hope you have a great day.